There's a fundamental promise we've made to our nation's veterans. When the evidence in a benefits case is a toss-up, they get the benefit of the doubt. But a huge Supreme Court case just put that very promise under the microscope. This is the story of Bufkin v. Collins.
So here's how we're going to break this all down. First, we'll dig into that core promise to veterans. Then, we'll meet the two men at the center of this fight. We'll unpack the legal jargon, see how the Supreme Court came down, look at the powerful dissent, and finally, talk about what this really means for vets today.
All right, so before we can even get into the case itself, we absolutely have to understand this one unique, really powerful rule that is the foundation for the entire veterans benefits system.
Okay, it's called the benefit of the doubt rule, and its history goes way, way back to the post-Civil War era. The idea is actually pretty simple, but it's incredibly important. Congress wanted the system to be pro-veteran. So if the evidence for a claim and the evidence against it are basically tied, the tie goes to the veteran every single time. It's like a thumb on the scale, put there on purpose, in their favor.
Now, this whole idea wasn't just some abstract legal theory for two veterans, Joshua Bufkin and Norman Thornton. For them, this was everything. It was the heart of a years-long battle for the benefits they felt they had earned.
So you have Joshua Bufkin, an Air Force veteran who was seeking benefits for PTSD that he linked to his time in the service. And then you have Norman Thornton, an Army vet, who was fighting to get his disability rating for PTSD increased. In both of their cases, the VA said no. And both men looked at their files and thought, wait a minute, this is a classic close call. This is exactly the kind of situation that benefit of the doubt rule was made for. And let me tell you, their fight was an absolute marathon. They went through every single level of the appeals system you can imagine, from their local VA office up to the internal Board of Appeals. Then they jumped into the federal court system, and they kept going all the way to the final stop, the United States Supreme Court. And what's kind of wild is that this entire massive legal battle, after all those years and all those courts, really just came down to the meaning of four little words that Congress wrote into a law. See, back in 2002, Congress passed a law telling the Special Veterans Court that it must take due account of this rule when it's reviewing a case. So the billion-dollar question became, what does take due account actually mean? Does it mean the court just gives the VA's decision a quick once-over to check for obvious mistakes? Or does it mean the court has to roll up its sleeves and do its own fresh review of all the evidence? And this slide right here lays out the two completely different arguments perfectly. On one side, you have the veterans. They argued for what's called de novo review, which basically means a fresh look, a total do-over, where the court weighs all the evidence itself. On the other side, you had the VA. They argued for a clear error standard. Now, that's a much more hands-off approach, kind of like a referee who only steps in if there was a really, really obvious bad call. So with these two competing ideas on the table, how did the Supreme Court finally settle this debate? Well, the entire decision from the majority came down to this one critical question. Is deciding if the evidence is basically tied a question of fact or a question of law? Now, that might sound like boring legal stuff, but in the court system, that distinction changes everything. Courts tend to let agencies make factual calls, but they get the final say on the law. This was the whole ballgame. And this quote from the majority opinion really tells you everything you need to know about their thinking. The court basically said, look, sifting through medical records, weighing what doctors said, considering testimony, that's a fact-finding job. It's not about some high-level legal theory. It's about getting into the nitty-gritty details of a case. So because they decided it was a factual question, the conclusion was pretty much inevitable. The Supreme Court sided with the VA. They ruled that the Veterans Court has to use that more hands-off, clear error standard. In other words, a court can't just step in and say, well, we would have decided this differently. And this was not a close call at the Supreme Court. The decision was a decisive 7-2 majority, with the opinion for the court written by Justice Clarence Thomas. But hold on, the story doesn't end there, because Justice Jackson and Justice Gorsuch joined her, wrote a really powerful dissent. They argued the majority had completely missed the boat. The dissent really focused on this one simple common sense question. Congress went out of its way to add those words, take due account, into the law. Why would they bother doing that if they didn't want to change anything? The dissent argued that the majority's decision basically erased that act of Congress, making it totally meaningless. Their logic was super straightforward. Look, if Congress just wanted the court to keep doing what it was already doing, using that normal clear error standard, then why add any new words at all?
By saying take due account was just a friendly reminder, the dissent said the majority turned a clear legal command into, and this is a great phrase, a meaningless exclamation point that has no real power.
Okay, so let's step away from all the legal back and forth for a second. What are the practical, real-world consequences of this ruling for veterans who are filing claims?
Well, the bottom line is pretty simple. The VA holds most of the power when it comes to these close call cases. It's now officially harder for a veteran to challenge the VA's judgment on appeal. The court has to stick with the VA's decision unless there was a clear error. And let me tell you, that is a very high bar to clear. Essentially, the system remains just as deferential to the VA as it was before. At the end of the day, the Bufkin decision really boils down to trust. The Supreme Court placed a huge amount of trust in the VA's process. And it leaves us with this really fundamental question to chew on. In a system that was built on a promise to always lean in the veteran's favor, how do you balance trusting a government agency with the duty to make sure every single veteran truly gets a fair shake?